I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. Today, I'm going to offer an update on a case that I just bet is going to be argued in the U.S. Supreme Court in October or November of 2022. In other words, more than a year from now. It has to do with a split of circuits, and it has to do with that rather dramatic increase in fees paid to the U.S. trustee system beginning in January 2018. There was a problem because the increase in fees did not become effective for several months, 8 to be exact, in the 2 states that instead of U.S. trustees have bankruptcy administrators. As a result, there were lots of lawsuits contending that these new and increased U.S. trustee fees violated the uniformity aspect of the bankruptcy clause of the Constitution. Well, everything went along swimmingly for a while. The 4th and the 5th circuits both held that, yep, no problem whatsoever, it's perfectly constitutional, even though the fees were dramatically different and much lower in 2 states. Aha! But then we have the 2nd Circuit in May of this year held completely to the opposite. In very unequivocal language, which is, shall we say, typical for the 2nd Circuit, the 2nd Circuit said, yes, indeed, there is in fact a violation of the uniformity aspect of the bankruptcy clause because it's a bankruptcy law and it was not uniform and it cost a whole lot more money in 48 states than in the 2 with bankruptcy administrators. Now, we have a split of circuits which is always very ripe for review in the U.S. Supreme Court. But this problem is going to disappear because the fees are now uniform everywhere. So you ask, why do I think that the Supreme Court will grant certiorari? The reason is there is also a class action pending in the district court in Washington, D.C., actually in the Federal Court of Claims. And in that case, it was dismissed. But guess what? It's going to get undismissed if the Supreme Court agrees with the 2nd Circuit, and I think that is a very distinct possibility. Why do I think it's a possibility? Well, over the last 120 years roughly, the Supreme Court has had only one really good uniformity case involving the Bankruptcy Act. And that, I think, was a decision involving railroads that today's current Supreme Court, which is much more strict about the enforcing the Constitution, I don't think, especially the conservative judges, are going to go along with it. And that's why I think we're going to have a grant of certiorari. Now, why is it going to happen so much later, not even in the term to begin in October? That is because in the 2nd Circuit case, the U.S. trustee who lost has filed a motion for rehearing and rehearing en banc. That means that the 2nd Circuit is not going to get around to denying those motions until sometime probably in the fall. And there is 90 days to file a certiorari petition. So therefore, I don't think the last briefs on certiorari are going to be filed until sometime, perhaps pretty late in the spring of 2022. As I said, I'm guessing that the Supreme Court will grant certiorari, but that means that argument will be, I think, sometime in the fall of 2022. Well, stay tuned. I will be giving further reports on the status of these cert petitions in my column, Rochelle's Daily Wire, on the ABI website. And I will be back same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, enjoy the summer. Good day.